start, you finish?
You go.
Right. Your Honor, I'll begin, and then Mr. Sonnenberg's going to finish. Yeah, I have to say, and I think the court recognizes that in the decades that I've been here, I don't recall the last time that someone who was not charged with any offense at all was hailed into a courtroom with the media put on call ahead of time, the prosecution coming forward with photos and making all sorts of allegations. When has someone been called into the felony arraignment room who not only does not have a felony, does not even have a misdemeanor, and in fact, take it even back further, has not even been charged with an offense? Clearly, at this time, he's been sitting in the Cleveland Municipal Jail. He's been there for 2 days, and he's not even been charged with an offense. So I would draw the court's attention to the same place that my colleague, Mr. Meyer, has, which is to Criminal Rule 46C. And when eliciting the factors for this court's consideration, I think it's very important just to simply go to subsection C1. And when C begins, in determining the types, amounts, and conditions of the bail, the court shall consider all relevant information, including but not limited to. The very first provision, number 1, the nature and circumstances of the crime charged. It is the very first provision of the rule that is applicable to this morning's proceedings. There is absolutely no crime charged. The writ that was filed yesterday is right on point. There should not even be a bond set at this point. He should be ordered released, because merely to come up forward and say we have these photographs and he's got connections and so forth, you can try and dirty a man up all you want, but the rules still require that if you're going to bring someone here in the court, there has to be a crime charged. That's not been done at all. He served his time. Any connections to family members and so forth by marriage, that is historical. His father-in-law is his ex-father-in-law, who has now since passed. There's been no connection, as reported, back to any families back in New York at all. What we do know is that he's been here, he's been in Cleveland, he's been living in Bentleyville with his wife, they've been married, they have 3 children, and the guy works tirelessly. It's one thing that no one's going to be able to contest. He's got the 3 yards in the Harvard and 116th area, and he works there day and night. So if they want to bring a charge and then talk about bond, that's fine. But you can't just bring someone in, hold up pictures to the world and say he's a bad guy, and then say, and we want a $1 million bond against this guy, but not charge him. There's got to be a process here. That has not been done. The writ is exactly on point, as I said, and respectfully, we would ask that this court order his immediate release. If the court does feel that a bond be necessary, then I call the court's attention to the next provision under Criminal Rule 46, which is when someone is here per summons, that even a personal recognizance bond be put in. Here, there's not even a charge. So when someone comes into a charge, that is what is preferred. When there's no charge, there's no basis for it. And Roger, do you have anything to add, please?
I really can't have anything, except, Judge, if you should consider setting a bond, and we believe he should be released on his own recognizance, we would ask that it be a very small bond. He has no passport. He is not a risk of flight. He's got ties to this community. He's had them for several years. He has a home here. His mother lives with him. His brother is sick in a clinic here in Cleveland. He's got 3 young children. He has no passport. None of these crimes that are alleged or even spoken about, I don't even know if they rise to the level of allegations at this time, are violent. The 2 guns that he refers to is a .22 rifle and a shotgun that was in his home, allegedly. But there's been no violence in his crime, in his past, in the past 14 years. It's been 14 years since he's been charged with a felony, Judge. He's turned his life around. He moved to Cleveland to turn his life around and get away from what they're trying to attach to him now. So we think unless and until he's charged with something, Judge, he should be released on his own recognizance.